Hi, my name is Jessie, and I am a student at the Indigenous Community Legal Clinic, also known as the ICLC, in downtown Vancouver. This video has been recorded on the unceded ancestral territory of the Musqueam, Tsleil-Waututh, and Stolo nations. This video is part 2 of Housing, Your Rights and Coverage under the RTA. If you want to know if the RTA applies to your housing situation, watch part 1 in this series, entitled Part 1, Coverage under the RTA. Now that we have provided some guidance on how to determine whether your housing situation is covered by the RTA, we will now discuss what rights exist under the RTA. This video will not discuss all of these rights in depth, but will cover a few rights that you may not know about or that are commonly disregarded by landlords. Overview of your rights under the RTA. As previously discussed, the Residential Tenancy Act gives tenants a wide range of rights relative to their housing providers. The rights you have include, first, rights around evictions. The RTA sets out rules regarding the specific situations when and when you cannot be evicted. It also gives you protections against things such as illegal lockouts. For more information on your rights around evictions, please see our videos on evictions, eviction step-by-step, the who and how, and eviction step-by-step, the why and when. Second, you have rights around repairs and maintenance. Your landlord has an obligation to maintain your housing in a state of decoration and repair that both complies with health, safety, and housing standards required by law, and makes it suitable for occupation. This means they are required to perform certain routine repairs, such as repairs to plumbing and electricity, and cover the cost of things like emergency repairs and insect control. As a tenant, you also have a legal responsibility to maintain reasonable health, cleanliness, and sanitary standards in your rental unit by doing things like taking out the trash and replacing light bulbs that burn out. For more information on which repairs and maintenance issues are generally the responsibility of landlords versus tenants, check out the Tenant Resource Advisory Center's page on repairs and maintenance. Third, you have rights around restrictions on rent increases. The RTA restricts how much your landlord can raise your rent by in a 12-month period. It also requires your landlord to notify you of any rent increases at least 3 months before they take effect. Fourth, you also have a right to quiet enjoyment of your rental unit, which includes rights to reasonable privacy, freedom from unreasonable disturbances, exclusive use of the rental unit, and use of common areas for reasonable purposes. Fifth, and finally, you have a right to have guests over, and rights that restrict your landlord's ability to enter your rental unit. I will come back to these last two in a moment. Note that these rights cannot be contracted out of. No matter what you sign, the policies put in place by your landlord or housing provider must comply with the RTA. If you think your landlord may have breached one of your rights under the RTA, you may be able to bring your dispute to the Residential Tenancy Branch for resolution. The RTB can provide a number of remedies, including monetary orders, orders for rent reduction, and orders requiring your landlord to cease the prohibited activity. For information about how to pursue your rights to the Residential Tenancy Branch, see our video on the RTB in this series. Now I'm going to talk a little bit more about two specific rights that you may not know you have as a tenant. These are your rights around guests and your rights around landlord entry to your rental unit, including for things like wellness checks. First, let's talk about your rights to have guests over. If your tenancy falls under the RTA, your landlord may not unreasonably restrict access to your property by guests you've invited over. Specifically, they may not, 1, stop you from having guests in your rental unit under reasonable circumstances. For example, they can't prevent you from having a friend crash at your apartment overnight for a few days. Or 2, they may not impose restrictions on your guests or require or accept any charge for daytime visits or overnight accommodation of guests. The courts have also clarified that landlords are not allowed to put in place building-wide policies restricting guests. For example, if your building only allows guests during certain hours, requires guests to show IDs, or limits the ages of guests, these policies would be unlawful. Also, these rules apply even if you are living in nonprofit or below-market housing. Now, there are a couple of exceptions to these rules. Your landlord is allowed to impose reasonable restrictions on your guests' use of common areas. Also, if the number of occupants in a rental unit is unreasonable, for example, if you have several guests basically living in your rental unit, your landlord may discuss the issue with you and issue a notice ending tenancy. Finally, your landlord can ban a guest if they have a good reason to do so. For example, if your guest has caused damage to the building or has interfered with other tenants. However, these exceptions are quite narrow. If your housing falls into the RTA and your landlord has imposed strict guest restrictions or makes you pay to have guests over, these policies are likely unlawful. Next, I want to bust some myths about landlord entry and wellness checks. If your tenancy falls under the RTA, your landlord may not enter your rental unit for any purpose unless one of the following situations applies. Number 1, you gave permission at the time of the entry or not more than 30 days before the entry. Number 2, at least 24 hours and not more than 30 days before the entry, your landlord gave you written notice, which stated both their purpose for entering, which has to be reasonable, and the date and time of the entry, which must be between 8 a.m. and 9 p.m., unless you agreed otherwise. Number 3, your landlord provides housekeeping or related services under the terms of a written tenancy agreement, and their entry is for that purpose and in accordance with those terms. Number 4, you have abandoned the rental unit, meaning that you have left your unit unoccupied and failed to pay rent for a continuous period of 1 month, or you have removed nearly all of your belongings from the unit. Even in those circumstances, your landlord can only consider your unit abandoned if you give oral or written notice that you do not intend to return, or if the circumstances of your departure were such that you could not be reasonably expected to return. And finally, 5, an emergency exists and the entry is necessary to protect life or property. In short, your landlord can only enter your rental unit with your permission or after giving you at least 24 hours notice, unless exceptional circumstances apply. Some housing providers conduct random wellness checks on their tenants. If your housing provider does this to you without written notice or without first obtaining your permission, they may be in violation of the RTA, and you may have recourse to the RTB. To recap, this video has provided an overview of your rights under the RTA and discussed the specific issues of guest restrictions and wellness checks. A really important thing to remember is that you cannot contract out of these rights. Even if your landlord has made you sign a document saying that you can't have guests over, or saying that they can enter your apartment at any time, these rights still apply, and you can enforce them through the RTB. I know that it can sometimes be intimidating to enforce your rights yourself. Fortunately, there are a couple of advocacy organizations that can help you enforce your rights under the RTA and seek recourse if your rights have been violated. If you are Indigenous and need assistance with assessing your situation or enforcing your rights against your landlord, please contact the Indigenous Community Legal Clinic at the University of British Columbia. You can reach the clinic intake line by phone at 604-822-1311 or toll-free at 1-888-684-7874. You can also visit the clinic in person in Gastown at 148 Alexander Street. If you are a tenant, you can also access the Tenant Resource Advocacy Center, commonly known as TRAC. TRAC has a team of lawyers and legal advocates who can provide free legal representation to eligible tenants living in British Columbia. You can start by calling TRAC's helpline at 604-255-0546 or 1-800-665-1185. You may also be able to qualify for free legal assistance and representation through the Residential Tenancy Program at Access Pro Bono. Depending on your issue, they may be able to help you file your application and appear at the hearing with you. You can reach them online or by phone at 604-482-3799. 3195, extension 1500. First United also provides legal assistance, advice, and representation to low-income and vulnerable people on the downtown east side with tenancy issues. They do intakes for new clients on Mondays, Wednesdays, and Fridays between 9 and 11 a.m., and on Tuesdays and Thursdays between 12:30 and 2:30 p.m. You can contact them by calling their intake line, 604-251-3323, or by dropping into their location at 542 East Hastings Street. Finally, UBC's Law Students Legal Advice Program provides free legal assistance for low-income individuals with tenancy matters. You can reach them by calling 604-822-5791, Monday to Friday from 10 a.m. to 4 p.m. Thank you for watching.
All Live Law Project content is provided by law students for informational purposes only. It is not and should not be considered legal advice. We're not suggesting that you make legal decisions based on any content included as part of this project without seeking legal or other professional advice. We cannot guarantee the accuracy of our content. The information in this project may not apply to you if you don't live in British Columbia or if the law has changed.